Hey guys, Roland Jones. So what happens when a trustee tries to claw back property instead of just cash in the context of a preference case or a fraudulent conveyance case, especially in the context of a crypto clawback? What are the implications? What issues arise, and how is that relevant? Again, this video is not legal advice. I'm not your attorney unless you retain me. The retention agreement has to be signed by both parties. Don't take any action based on this video or anything you hear in this video. Don't refrain from taking any action. Get a lawyer. Also, video might be construed as attorney advertising. You can stop watching if you don't want to watch it. And nothing I say in this video is an admission or a waiver of any kind. We'll talk a lot about 550 of the Bankruptcy Code and why you should care about that. What's the timing of valuation of property? You might want to care about that. Whose standpoint is the valuation of the recovery measured? You're going to care about that. And under what circumstance does the court permit recovery of property? When does it direct the recovery of the value of the property? You might care about that. And recovery in cryptocurrency cases. If you're involved in a potential cryptocurrency clawback situation, this video will definitely be relevant for you if the claims are filed. And I'm going to talk about Hashfast and explain why later. So 550 of the Bankruptcy Code authorizes the recovery of the property or the value of property to satisfy a transfer of goods. So trustee's got to win first and get the judge to rule that a 547 preference, 548 fraudulent conveyance should be clawed back and pursuant to those code sections. And the next step is to actually claw it back. That's what 550 does. 550 is the mechanism by which the property or money is actually clawed back. So this was 550, except as otherwise provided in the section, blah, blah, blah. 547, 548 of this title, the trustee may recover, comma, for the benefit of the estate, comma, the property transferred, or if the court so orders, the value of such property. And there's a big difference, as we're going to see. Trustee's going to rely on this, better watch out. So, what kind of questions does this raise? When should property, not value, be returned to the estate pursuant to 550? At what time is the value, if it is a valuation situation and the judge is going to do a valuation of property and not compel the return of the property, when is the valuation? Time. Is it at the transfer date? Is it at the petition date? At the clawback ruling date? What if the property appreciated? We know that in certain situations in crypto cases, property did appreciate. Does the estate get value at the time of the value at the time of the transfer? Does the estate get appreciated value? What if defendant sold the coin and the judge rules the property has to be returned? Does the defendant have to go out and buy more coin and then hand it over to the trustee? Does the estate get to be in a better position than without the transfer? So is this a great deal for the estate? Is opportunity cost an argument so that the estate gets the appreciation, or is it unfair that if a property is appreciated, is it unfair that the estate gets that appreciation, gets a windfall? What if property depreciated? If the estate can get a windfall, should it not also take a loss if the property depreciates? Should we be consistent about that the principle? Is it fair to make a defendant pay the difference out of pocket? Because if the property depreciates, that might be what's going to happen. A lot of questions here. And there aren't very easy answers, and there's not a ton of case law. So if you're confused, so are a lot of folks, including lawyers. What the heck's going on here? And then it gets even more confusing and basically no law whatsoever on these issues. If crypto appreciated after a transfer, should defendant return the crypto? Should a defendant be forced to buy new crypto and turn it over? When was the crypto even transferred? What's the date of the transfer date? Should a defendant contribute cash if the crypto depreciated? If debtor accepted payment in crypto, shouldn't crypto be treated like a currency, or is it a commodity? If there is speculation in dollars as well as crypto, what's the difference? People treat dollars as a commodity. They speculate all the time in dollars. If the dollar appreciates, can clawback defendants pay less. If we're going to do that, if we're going to say just because you speculate in a currency, are we going to apply that to dollars? Shouldn't we be fair about that? Apply it to dollars as well? Of course, it's never done that way. If the dollar depreciates, should trustees get paid more money to make up for the depreciation? If we're going to be consistent, and we're calling crypto a commodity, isn't a dollar a commodity in a sense? It's speculated. The value is speculated on a daily basis. Is it unfair to treat crypto differently than currency? Anyway, you can. I'm sort of hinting at some of the arguments that I'm going to be making and some of the issues that have come up. But there are a lot of questions and there are not a lot of answers. Who knows what's going to happen? I thought this was a pretty good article. It's recent, January 2023, pretty recent. Buchanan is a well-known firm, and you can see it's going to ask the questions that I just asked. Very simple. If they liquidate the cryptocurrency and the value increases, they may have to buy it back at a higher price if the court orders the return of the cryptocurrency. Conversely, if the value of the cryptocurrency drops, customers who retain the cryptocurrency run the risk they will have to pay US dollars to make up for the price, essentially, and will not be able to liquidate the cryptocurrency for a sufficient amount. Equally concerning for customers is there is no bright line regarding the valuation date. It could be the value of the cryptocurrency at the time of the withdrawal, bankruptcy file, clawback lawsuit, clawback judgment. What the heck is it going to be? The law is not clear. Customers should carefully consider hedging strategies. They may want to ask the court to decide the valuation issues early in the case, or maybe they don't want to do that. Strategy issue. One of the main problems in the issue, what to do when the property appreciates and what's fair and equitable, is that there aren't a lot of cases. They're rare. They're extremely rare. I mean, there are some out there. A lot of them are not at the higher level, at the bankruptcy court level. So you don't know if a court of appeals is going to reverse the decision. Very few at the district court level. So it's very hard. I can't use my crystal ball. Crystal ball is very cloudy because the way lawyers predict outcomes is by looking at precedent. Here, there's not a lot of precedent. So what are we going to do? Who knows? I want to talk about this case because it's a property appreciation case. It's at the Court of Appeals level, and it points out some general principles. 2004, so it's not that recent. 10th Circuit. Yeah. So what happened here is that there was a company that spun off a subsidiary to shareholders. So it spun it off as a dividend, and basically and then the company, of course, went bankrupt. And the trustee was appointed, and the trustee said, "Hey, we didn't get any creditors." And the estate got nothing for the spin-off of the stock. And so we want the stock back or you have to pay up. Was not reasonably equivalent value. The company basically gave it away to shareholders. It was inappropriate to pay a dividend at that time, blah, blah, blah. I'm not going to go into all the details. You can read it, but basically that's the summary of the case. And so what happened was there was a settlement, there was a class settlement, and some of the shareholders appealed that because shareholders felt that the settlement required them to pay back too much money. So what happened here is at the time of the transfer, when the company spun this off and gave these shares to the stockholders as a dividend, the shares were worth around $5 a share. But the class that negotiated with the trustees settled to pay back $7 a share. And so the shareholders basically were saying, why should we have to pay back more than what the value of the stock was at the time of the transfer? And the court said, we're not going to overturn the settlement because the property appreciated. And it's certainly possible that you could have paid more in an eventual clawback if there had been a clawback action, because you have to pay back the appreciated value. There's one case that disagreed with the court. The court disagreed with that case and held with the one case that it found that said in the situation where there's a clawback, you have to pay back the appreciated value. And there's no ruling. The court was unable to rule, in detail as far as exactly when the appropriate valuation would take place, but the court ruled that there was certainly a possibility, and the settlement was reasonable at 7 because it could have ended up being a much higher number. Not a lot of guidance because the fact pattern is hypothetical and not even sure what to do with this ruling. But it gives you a concept of, not even sure this is a holding on this issue, but it gives you a concept of how this court was thinking about it. And if I were appealing, if I were in the 10th Circuit and I had a case on appreciation and whether the defendant had to give back the appreciated amount or the value at the time of the transfer, you know what I'm going to be thinking with this decision. I'm going to come back to this later, but I think it's outrageous. I disagree very strongly with this position. Clawback laws are not punitive, especially the preference laws. There's no punitive aspect to that. And this is extremely harsh because if you got appreciated property and you sold it, which is very possible, then you have to go out and buy appreciated property. And your clawback is actually higher than what your clawback was. So you're doing more, you're paying back more than what you actually got. And there's nowhere in the bankruptcy court that's in the bankruptcy code that says that, and it's unfair. It's very punitive, just not right. So I'm going to go back to this later and give you more arguments on that. We're going to go over a callback case involving in kind, where I think the court got it right. It's the market price at the time of the transfer is the appropriate measure. This is an older case, and it's also bankruptcy level. So it's a horrible case. I mean, I'll tell you what happened. So there was a pre-purchase by a creditor of a lot of whey, whatever whey is, WHEY. So they bought tons and tons of whey, millions of dollars worth of whey. They prepaid for the whey, prepaid for it. Then the company goes bankrupt, and then there's a delivery of the whey after the bankruptcy. And it's not a clawback case. Well, it's essentially it is a clawback, but not 547 or 548. It's a 549 clawback, and there's a clawback because the property, the whey should not became property of the estate and should not have been delivered based on a pre-petition, pre-bankruptcy prepayment, but it was. And so the court basically said the creditor had to return the whey. So in other words, not only did it lose the money that it used to prepay, but it has to go find whey or pay the value of the whey, give the whey back, or pay the value of the whey. It's a horrible case. Horrible. I'm not saying the ruling was horrible. I'm just saying it's a very harsh result for this particular creditor. And it just goes to show you have to be very careful when you accept property from a company that's gone bankrupt. And maybe they had a claim against the estate, but most of these estates pay out very little. So I'm not optimistic that they're going to be compensated for this. But anyway, I digress. As to the measure of the damages, the method of computation advanced by the committee is obviously correct. The market price at the time of the transfer is the proper measure of damages because that is what the debtor would have been able to get for its whey had it not been improperly transferred. I agree. That is the proper measure of damages. The problem here is that the court doesn't really go into, did the whey appreciate? Did the whey depreciate? Is the whey worth exactly the same? It's not even addressed. So it may not be relevant to an issue, a case or a fact pattern where property is transferred and it appreciates or depreciates. They asked me for my money back in the last case. I would have just said, no way. Sorry, I had to do that. I'm going to talk about some cases where the property depreciated, then I'll go into cases where the property appreciated. Where you're going to find, and I think it's very unfair, is that when the property appreciates, then the court is going to order a return of the property because it's better for the estate. The estate gets the windfall. So some courts do that. I'm not saying all courts, and I think the case law is sparse on appreciation. I've already said that, and there are not a lot of decisions not a lot of rulings, not a lot of precedent at the higher levels. So really don't know what the law is, but there definitely have been some courts that have said that. So you have to watch out. And then if the value depreciates, we don't want the property. Just give us the cash at the time of the ruling, at the time of the clawback, or at the time of the petition. Again, it's in favor of the estate. So is that consistent? Is that fair? Is that right to innocent creditors? Very misguided. It's an important principle that the judge is in charge here of making the decision because the statute's not clear, the case law is not clear, nothing's clear. So you're really depending on the judge to make the equitable decision, and it's going to be open to arguments. You're going to need good counsel, good arguments. This is a case that says that 1998 case. So this is a fraudulent conveyance case. Apparently, insurance policies were transferred from one entity to another entity. The first entity went bankrupt. Trustee wanted the insurance policies back. And the judge was faced with a decision. This is, do we return the property? Do we return the value? When do we do that? All kinds of issues that I pointed out earlier. And the main point here is that 558 is intended to restore the estate to the financial condition it would have enjoyed if the transfer had not occurred. Yes, but to me, that doesn't mean more value. Doesn't mean it gets the windfall of appreciation. That's the principle. Anyway, however, since the bankruptcy code does not provide guidance on when the court should order payment of the value of the property rather than order the return of the property itself, there's no guidance. You gotta make it up as you go along. It is within the court's discretion to make such determination. When there's not a lot of case law and the judge has a lot of leeway to make a decision, your guy better be on the ball. The factors which the court should consider in determining whether to order turnover of the property rather than payment of the value includes whether the value of the property, 1, is contested, 2, is not readily determinable, and you can think about crypto there, or 3, is not diminished by conversion or depreciation. So here, the trustee found that these factors militate in favor of turnover of the policies. Give us the policies back, and that was the decision. By the way, this was Burton R. Lifland. He was chief judge in the Southern District for a long time when I was starting out. He's a great judge, and a lot of fun to argue in front of. Something to watch out for is that if it is a valuation case and the court's going to order the value to be returned, whatever time that's going to happen, the court's going to take into account the debtor's perspective. It's value from the debtor's point of view, not from the recipient of the property's point of view. And I'll give you an example. So this case is basically a bust out, which is a mafia term. It's just like Goodfellas. You see Goodfellas in there that they had the restaurant. So basically they ordered a bunch of stuff from the vendors. They had no intention of paying, and then they sold all this stuff at the back door at a deep discount. So that's what happened here. This entity, the debtor, bought a lot of spark plugs, didn't pay anybody, and then sold them at a deep discount. So went bankrupt. Trustee sues the recipient of the spark plugs that got too good of a deal, and trustee says we want the spark plugs back, or we want the value. Actually, the value of the spark plugs probably depreciated. And then the argument was by the entity that bought the spark plugs, we'll give them back to you at. So the entity that bought the plugs said, okay, we'll give them back to you at 84 cents a plug. And the trustee says, no, I want 94 cents a plug. And the argument is to the trustee who can liquidate the plugs, it was worth more than the deeply discounted price that the entity that bought the plugs were able to buy them for. The entity bought them 84, but debtor can get 94. So that was the argument. And the court sided with the trustee. And the principle is what's important, what's relevant to evaluation is what the debtor can get, the value to the debtor, not what the value was at the time of the transfer, or what the payment was, the price was at the time of the transfer, is the value to the debtor. That may come up in cryptos. The value of the preference that is recovered is determined from the viewpoint of the trustee. So this is a summary. This is because where preference is recovered by the trustee, the entire preference is recoverable without deducting therefrom any costs attributable in favor of the preferred creditor. So this is another example. So in this case, there was a clawback, and this was a preference clawback. And the issue was, we're at 550, so someone's already lost. Usually, if they're litigating a 550 issue, someone's already been ruled to have gotten a preference or a fraudulent conveyance. So that was the case here. There was a preference, and the argument that the defendant was making, we got the 7,000 and change, but we had to pay our lawyers to collect this money. We sued the debtor. We had to put, we didn't get the whole thing essentially. So we should only have to pay back what we really got, which makes sense. Trustee said, no, that's your problem. It's life in the big city, and you're going to pay back the amount that we paid, that the amount that the estate paid. You're going to have to pay it all back. What are you going to do? You can always ask the trustee for a break, see if he has a little compassion. So when does a court order return of property? When does it order payment of value of the property? The default basically is return of the property if that's the situation. 1985 bankruptcy level case. You can tell I'm going all the way back because there aren't that many cases. There are more cases. I cite more recent cases. So here the trustee won clawback. It was a piece of real estate that was transferred from one entity to another entity, and trustee won. And he didn't want the properties. just cut a check. I guess he didn't want to deal with the headache of selling the real estate. Just give me a check. Give me the value. And what happened was the judge said, no, you're going to get the property. When valuation is an issue, then in this case, the principle is courts will generally allow the trustee to recover the value of the property where the subject property is itself unrecoverable. But here it was recoverable. Other courts award a return of the property where evidence in the record does not establish the value of the property transferred. From the foregoing decision, it is clear that courts favor return of the property if at all possible, so as to avoid speculation over its value. And here there was some litigation as to value. So the court, it's easier if you just take the property. We don't have to go through all those valuation questions. And so that's what the court ordered. So that's something to consider. Based on the language of 558, courts find a congressional intent. I've seen courts, some rulings say that there's a congressional intent to return the property transferred unless to do so would be inequitable. I don't know. Where is the congressional intent? So most courts find it default to transfer the property, and this is why. The trustee may recover, comma, for the benefit of the estate, comma, the property transferred. That comes first. Number one, let's do that. Or if we can't, the implication by these courts is, or if we can't do that, or it's not a good thing to do that, it's not equitable to do that, or any other reason, or if the court so orders, comma, the value of such property. So by this construction, some courts have decided that there's a default. I don't really see a default there. It seems like just a disjunctive option that the statute gives the court. I don't see how you can read a default for property, but some courts have. What do I know? So this case is about a fraudulent conveyance of common stock. Again, 1987. It's old. Yeah, so I'm not going to go into even the facts of this case, but I'm going to show you here. 558 does not state at what time the value is to be determined based on the language of the court finds a congressional intent to return the property transferred unless to do so would be inequitable. That's what the court found in 550. This approach avoids unnecessary contests over the meaning of the term value and thereby promotes judicial economy. It's easier. It just requires less litigation, requires less speculation. Just give the property back. Much easier. So I think that's basically the justification. Why fuss around valuation and all the issues that valuation bring up and the experts and the evidence? Just give the property back. Much easier, if possible. The problem is, what if the property appreciated? That's a big problem. because if the property appreciated, what if you no longer have the property? You can't just give it back. You have to go buy it. And that's the problem. You're going to be hit with the appreciation. It's not what you got, not what you got transferred. And normally, what you in 99% of the cases, you pay back what you got. Here, you're paying back more than what you got. You're taking a hit here, so it's a real problem. And the circumstance of this decision making by the judge, you've already lost. So the judge has already decided that you've gotten that fraudulent conveyance, or you've been preferred. And so the judges are human. I don't think a judge is going to be inclined to lean in your favor and say, "Oh, you can keep the appreciation. Let's do that. Let's give you the appreciation, and not try to make whole, hundreds or thousands of creditors that are getting killed because of this bankruptcy." So, what's the judge going to do? Favor you? So what's the judge going to do? It's a very tough situation. It's easier. It makes sense to give back the property. You don't have to deal with valuation, experts, etc. But in a situation where the property is appreciated, it's not fair to the defendant because you're forcing the defendant to essentially pay more than what was transferred pre-petition prior to the bankruptcy. And it's even more unfair if the defendant has to go out and buy the property at an appreciated price. It doesn't make any sense. The court is a court of equity. I think the court has to consider the fairness of the issue and has to side with the defendant on this situation. The court has to look at all the circumstances, but I think the court has to fall on the side of the defendant, given the brutal outcome that's possible here. The property depreciates, it's just as bad. Got another problem, but it's essentially the same harsh result. When a debtor cannot be made whole by the return of the property lawsuit involvable because of the depreciation value of the property, the court may enter a money judgment, cut us a check, make us whole. So again, it's not what was transferred at that time. It's looking at what happened later, which is inequitable and not really in keeping with the theoretical underpinnings of what clawback laws are about. They go back in time. Why should a defendant essentially guarantee the value of property simply because it got a transfer? If the trustee can go back in time to undo a transfer, the trustee should get what he finds at that time. That's the appropriate time, the transfer time. With cash payments, it's always the transfer time. Why shouldn't it be the same with property? Why should this issue even come up? Defendants should not be insurance policies. What if a company is considering bankruptcy? Let's pay a bunch of vendors property because we think it's going to depreciate, and then we'll sue them for clawbacks. They'll make up the difference. It's a great insurance policy. Let's pay everybody. Let's give this. Let's transfer this property because we know it's going to go down, and the court's going to make everybody pay the difference. I think it's a great strategy. It's a disaster to let something like this happen. So this is an example of a depreciation case. Essentially, before the bankruptcy, the company gave back software it was unable to afford. There was a ruling that this was a transfer, and the recipient, it was a preference transfer, and the recipient said, "Okay, we got a transfer of this property. It's a preference. We'll give you back the property." Unfortunately, the software had depreciated to next to nothing, and so the trustee didn't want it back. Wanted the value of the property back, and the judge agreed. In this situation, when a debtor cannot be made whole by the return of property lost through an avoidable transfer because of the depreciation in value of the property, the court may enter a money judgment equal to the property's value as of the date of the petition. So, the defendant had to make up the cost because of this depreciation, had to make up the cost of the depreciation. I think the better policy is that if there's a preference and it involves property, in this case software, here, take your software back. And there's no issue as to whether the property appreciated or whether it depreciated. The estate is put back into the exact situation that it was in before, with depreciating, with property that's depreciating. That's where it was before. I think that's a lot simpler. Also, you avoid all these valuation issues. So in both these situations, preference recipient is giving back more than what the estate actually had at that, what was transferred at that time. I don't think that was the congressional intent. I mean, preference clawbacks are already brutal and punitive, even though they're not meant to be punitive. And so we're going to add this additional punishment. I think it's bad policy. It's disaster. Another fraudulent conveyance case, transfer of real estate. I'm not even going to go into the facts. You can read it if you want. Basically, a ruling on a fraudulent conveyance of transfer of real estate. And the ruling is, finally it's clear that should BRE retain this property, the trustee is entitled to at least the amount of the greater of the value at the time of the transfer or the value at the time of the recovery after improvements. And there wasn't apparently any evidence of improvements. So again, the trustee gets the windfall if the value has improved. And it's not really surprising in the context of a fraudulent conveyance case that may involve bad faith, either on the part of the recipient or the transferor. That I can understand. But in a typical preference case, where there's no evidence of wrongdoing, there's no allegation of wrongdoing, just happen to get paid in the preference period, seems unduly harsh. Section 558 demonstrates the intent of Congress that any appreciation, and this is a quote from the case, not attributable to the actions of good faith transferee inure to the benefit of the estate. Where? Where did it say that? I don't see that. Do you see that here? I don't see that here. They don't cite any legislative history to support. No one cites any legislative history to support that. This is a transfer of property and a judgment that there should be the payment of value, not the return of property. So I'm going to go right to the relevant part of the opinion. And just the bottom here, at least two courts have recognized the trustee is entitled to recover the greater the value of the transfer of the property at the transfer date or the value at the time of the recovery. Two courts, not a lot. And that's Collier is the major treatise on bankruptcy that a lot of judges quote from. And if you go to law school, you'll read Collier's. As noted by Collier, this result is consistent with the well-established purpose of 550, to restore the estate to the position it would have occupied had the property not been transferred. I disagree. The estate would have had a depreciating asset. So what? That's what it would have had. It wouldn't have had. It wouldn't have been in the unless you're going to predict the future. You're going back in time, and then at the time of the transfer, we're predicting that this appreciation was inevitable. So when you're calling back, you're going back in time. It's a fiction, and now we're going to anticipate that this property would have appreciated. No, you have to look at what happened at that time. Who knows? Maybe it would have depreciated. Maybe it would have appreciated. Maybe it would have stayed exactly the same. That's what the estate had. To put the estate back in the position it was in, give them back the property. Forget about additional payments. Some courts try to make a distinction between property that appreciates on its own and property that appreciates because of the effort of the defendant. It was a pretty recent case, bankruptcy court level again, not a higher court, 2014. It's always sad when a law firm goes bankrupt, but that's what happened here. So the law firm, before it went bankrupt, it gave away some of its cases to another law firm. I'm assuming, contingency cases. And so there was and when a bankrupt trustee was appointed, trustee sues the other law firm that got the cases for a fraudulent conveyance and saying there's no reasonably equivalent value. You didn't pay for these assets, these potential cases, so you have to pay up, and you have to pay the value. How are you going to return? There's no one to return the cases to. So you can't return the cases as property, and you have to pay the value of what these cases are. So the lawyers that were being sued came up with a creative argument. They're lawyers, and what they argued was you have to determine the value of these lawsuits based on the capacity of the law firm at the time before they were transferred, and the judge agreed. The problem with that is that it requires the court to do a hypothetical. What were these cases worth at the time for this particular law firm that went bankrupt? In other words, Heller is entitled to what the trier of fact determines to be the objective net value of the unfinished business based on the hypothetical continuation of that business to completion by an ongoing firm with Heller's characteristics. And this leads you into a rabbit hole of valuation, of hypotheticals, and the better rule would just be to return the property, whatever it is. Let them give back the cases to the trustee. Let him prosecute them. I think the equitable outcome in all these cases is if the property depreciated, take back your property. That's what you would have had before, depreciated property. If the property appreciated, then you get the value of the transfer. That's the fair outcome. I'm going to shift gears and talk about some crypto analysis, crypto stuff, because there are a lot of crypto cases out there, potential cases. Maybe there won't be any cases, but there seems to be a lot of cases coming down the pike. So this is a good article, Pratt's Journal of Bankruptcy Law, fairly recent. August 21, not that recent, but pretty recent. And so it summarizes it pretty well. The Bankruptcy Code does not define value or indicate at what time value is to be determined. Those advancing the position that cryptocurrency is currency have a simple response to this challenge. The recovery can only equal the transfer, and a transfer of $100 leads to a $100 recovery. Alternatively, those advancing the position that cryptocurrency is a commodity respond that the value of the property transferred should be determined at the time of recovery, and thus the trustee is entitled to $10,000 and then they go into the appreciation issue. I'm not reading that, but you can get the article if you want to. There's no clear consensus on the time at which to measure value. The cases are scattered; they're all over the place, and a lot of them are at the bankruptcy court level. So you don't know if they're going to be reversed. Well, they weren't appealed, but could a district court or a court of appeals take a different view? Certainly. All right, I'm going to talk about hash fasts. I thought it was a very interesting case because we have the briefs for that, and they go into these issues in a lot of depth. Northern District of California. There was no ruling in this case. I'll go into why, but still, it's a good exercise to go into these arguments. Plaintiff argued that Bitcoin should be treated as a commodity if the chances of Bitcoin are avoided. Here, they actually were not avoided yet. Apparently, they were seeking a ruling on summary judgment before there was a ruling on whether there was a clawback, which I kind of get that strategy. I think you should probably figure out if there's a clawback first. Why spend money on deciding what happens after a clawback if the clawback has not even been decided? Anyway, someone was paying for this, and I have a different opinion on the strategy. No offense to the lawyers at hand. Maybe they knew something I didn't know. All right, this is the trustee who's trying to, wants the clawback. 2016 is the date of this, so it's a long time ago. But unbelievably, there hasn't been a lot of law since then. Better watch out. All right, this is the table of contents. I'm going to skip that. Skip that. There is no published case law on whether Bitcoin constitutes currency for the purpose of Section 550A. There still isn't, as far as I can tell. If you have case law like that, by all means, share it with me. I haven't been able to find any. However, but there will be, I think, pretty soon. However, two different government entities, CFTC and IRS, recently addressed whether Bitcoin constitutes currency. Both come down squarely on the side of not currency. Okay, so these are government agencies. They're not federal courts issuing rulings, especially especially rulings on 550A. Yeah, so they go into the agency and the attitude of the agencies, and it's going to be different. You can't pay your taxes with Bitcoin. Okay, does that mean it's a currency? There hasn't been a federal court that said that. And there are other arguments also with respect to government agencies and tax issues. So the plaintiff here is citing cases that appear to support his position. All cases could be distinguished, and there are also not a lot of cases. So other courts might disagree. They just haven't been faced with the issue. Would a court that has to rule on this issue, and there are 10,000 crypto defendants out there that are going to have to buy crypto at inflated prices to satisfy a ruling, is that judge going to have the same ruling? Maybe not. And another agency dealing with a federal agency dealing with money laundering has treated Bitcoin as a currency. But again, it's an agency. It's not a federal court making a ruling with respect to bankruptcy, clawback, or 550. My skepticism there. All right. Now we have the defendant. Defense. So the argument, of course, is going to be that Bitcoin is more like a currency. Every case the trustee cites, even those who do not cite, treat Bitcoin as a currency, not a commodity. Blah, blah, blah. Everything about the way Hashfast treated Bitcoin. So the argument is the defendant here treated Bitcoin as a currency. I think he was paid in Bitcoin, and the parties treated it practically as a currency. And the argument, and it goes on to argue, which I'll show you, is that arguably Bitcoin was treated as a currency by the bankruptcy estate. So it goes into the agency. Some agencies do this, some agencies do that. Don't know how relevant that is. Not a ruling. There he is. He's fighting back, doing his best. So those arguments, I'm sure, are going to be made. There are only a handful of court decisions on whether Bitcoin should be treated as a currency or something else. Well, all of them have treated Bitcoin as a currency. There's not a single federal case that's ever ruled or stated that Bitcoin should be treated as a commodity or a currency. There's no federal bankruptcy case on this. Yeah, for the purpose of the money laundering, my face is in the way, but for the purpose of the money laundering money laundering laws, but it's not for the purpose of 550A or clawback, or even in a bankruptcy context. So there are arguments against both arguments. I'm not going to take a stance at this point. I'm just going to point out the arguments. There are issues, and these are the arguments that are going to be made. The trustees and our argument is premised on the idea that the relief sought by the motion is consistent with the purpose of restoring the estate to the financial condition it would have enjoyed had the transfer stopped. But the trustee is not taking the position that to deny the motion, denying creditors the estate of $1 million as a post-transfer appreciation. But the trustee is not taking the position that creditors who paid in Bitcoin are entitled to their property back. Quite the opposite. The trustee has always made clear that creditors would only get the cash value of their investment at the time it was made, even if they paid in Bitcoin. So, arguing that it's hypocritical. Also arguing the disclosure statement, page 61, goes on to say any payment of cash made under this plan may be made by check, drawn on account of the Hashfast creditor, by wire transfer, by automatic clearinghouse transfer, or transfer of Bitcoin. I think that's a great argument that the defense is making. The defense seems to me is trying harder. Why? Because the defense has much more to lose. The defense always tries harder. It's obvious that Hashgraph did not hold Bitcoin for long-term appreciation. It's not a commodity. We're treating it as a currency. It's obvious. It's a currency. I guess the argument is here, Bitcoin should be treated by the court as it was treated by the parties. If there's a coin flip between whether it's a commodity or currency, then how the parties viewed Bitcoin, how the parties used Bitcoin should be evidence in favor of treating it as a currency. Even if the court finds that Bitcoin is a commodity, the same analysis above will weigh in favor of finding the value of the product as the correct valuation. Contrary to trusted, the court need not and should not automatically take the highest valuation. Indeed, a bankruptcy court only determines the value of the property to be value at the time of the transfer, and that's correct. That is the normal time, the traditional time to value a property, but has the discretion, true, on how to. I want to get to the part where he's making my argument. Moreover, Hashfast paid a very specific defined USD commission for Dr. Lowe's services, so they happen to have accepted another currency equivalent, in this case Bitcoin. If the services are held to be not up to standard, not that they should be, he should not have to give up many times what he negotiated for and was paid. It's not fair for him to have to go out and buy appreciated Bitcoin and pay more than he got back. Than he was paid, more than the clawback. It's punitive. Additionally, it's not equitable. Additionally, it's beyond dispute. Trustee would not be arguing that Bitcoin is a commodity or property that Bitcoin had depreciated. Of course not. Take the other point of view. We don't want your Bitcoin. Cut a check. Trustee's motion impermissibly. I'm not sure about that. Some courts find it very permissible. Rests on a heads I win, tails you lose theory of recovery. It's entirely inconsistent with the principles of basic fairness, blah, blah, blah. Maybe, maybe not. Those are the arguments. Those are the issues. And here's his reply. Empire Strike Back. Yeah, so, he's arguing, well, it doesn't matter if it's currency or commodity. We get the appreciation. And I'm going to cite cases that say that. I'm going to cite a Court of Appeals case that says that, and there aren't that many. All right. Blah, blah, blah. You can read this if you want. I think I covered the main arguments. Is it currency? Is it a commodity? If it is a commodity, do they get the windfall? Does the estate get the windfall or not? Is that fair? Is that punitive? These are all very tough decisions. A decision is going to have to be made by someone, by some judge at some point, and it's a very difficult decision. I think there's going to be an element of coin flipping here. I don't see how a decision is going to be made. There's going to be a rationale, but there are rationales for both sides. Very difficult. Of course, I think I'm leaning, of course, as I represent defendants, that it's inequitable. It's just inequitable because a defendant shouldn't have to pay. And that's my position. Defendant shouldn't have to pay more than he got. I mean, it's just not right. It just doesn't make any sense, especially in a preference case where there's no fault implied, there's no bad faith implied, just an unlucky situation. And so, okay, we're gonna order a clawback, and in addition to that, we're gonna order a clawback more than what the property was worth. Or if a property went down in value, you're going to make up the difference, defendant. It's just not equitable. Anyway, beat a dead horse. So basically the judge said, which is what I said, is like, let's determine if there is a clawback to start with. I'm going to say it's not a currency. Rather, it's sufficient to determine that despite defendants' earnings, the cost of Bitcoin are not United States dollars. It doesn't say it's not a currency. It just say it's not United States dollars. And then basically says, we got to find out if there's a clawback first. Let's do that first. Okay, I already said this. You have my take. And this is conclusion. I'm not going to beat a dead horse. You can read it. Those are the factors. And again, the main thing you got to take away is there are not a lot of cases, especially on appreciation. There are a substantial number of cases on depreciation, but in most crypto situations, the issue is appreciation. There's not a lot of guidance out there. So someone's going to make new law. And thanks for watching. Again, if you're facing a clawback, uh, especially if it's of any substantial size, um, get a lawyer. I mean, you need to consult with someone, I think. And that's not even advice. And nothing in this, again, nothing in the video is advice to you, to anybody. It's not, don't take any action on anything you hear, anything I said. Don't refrain from taking any action. Again, you got to get a lawyer who you trust, who's going to go over the specific facts of your case and advise you properly. And maybe do some prep work for this if you think you're going to be sued. Um, and preferably, so I would advise getting at least a bankruptcy lawyer, and preferably someone with a lot of clawback defense experience, um, because this is a niche area if there ever was one. There are a lot of subtleties here. I'm not saying you need to retain me. There are a lot of good people out there that have handled a lot of cases, done a lot of defense work all over the country. But get someone good. It's my advice, because you don't want to screw around with this. And this is black belt level clawback defense.